The result of a negotiation could be that infringer ends up licensing the patent from you. You may end up giving them some rights in a limited field of use, for instance, to be able to practice your invention in exchange for, some royalties, some other kind of payments of the sort.
You are listening to Intangiblia, the podcast of intangible law, plain talk about intellectual property. Please welcome your host, Leticia Caminero.
Hello and welcome to episode 6 of the second season. On this opportunity, we are going to learn that you don't need to create a unicorn in order to be successful with your inventions. Let's welcome our guest.
Hello, my name is Joanna Brougher. I am American, although my background is a little bit more complicated than that. My parents are from Russia and Estonia, and I was born in Germany. So I grew up speaking several different languages, including Russian, Polish, and German, before moving over to the U.S. My age, I like to tell everyone I'm 29, but sadly, I don't think that is the case anymore. I'm a little bit older than that. And I'm a patent attorney by training, although I have expanded my career to be more kind of a general IP strategist, I would say.
Tell me about your journey of becoming a patent attorney and IP strategist.
So my journey was also kind of not a straight line. I started off studying infectious diseases. So I really wanted to become a doctor of infectious diseases, which is kind of ironic given today's climate. So I studied microbiology and immunology in undergraduate. I also got a master's in public health where I got to focus on epidemiology. Again, I really liked infectious diseases and saw myself kind of working in the field with that. But then something happened and I worked with a really great lawyer at the School of Public Health that I was at. And she kind of introduced me more to the legal side of medicine, which I thought was very, very interesting. And after working with her for a couple of months, I decided, I think that I'm going to go to law school. And so I ended up in law school. I thought that initially I was going to be a healthcare attorney. That was kind of my goal at that point. But then when I ended up joining a law firm for my second year summer internship, I was put into the intellectual property group. And in that group, I really kind of discovered that I enjoy working with technology companies. I enjoy the challenges of working with these companies and also the excitement of working with them. They're working on technology that the market's not going to see for another 10 to 15 years. So there's, some excitement with all of that. And especially in the medical field, where you get to see what is coming down the pipeline a decade or so later. And I think that was always very intriguing to me. It also ended up coming kind of easy to me, which, is always kind of fortunate, I would say. So I really enjoyed intellectual property. I enjoyed the patent space. I enjoyed the fact that something new is constantly happening in the space, either on the technology side, but also with what's happening in the courts. I was told by one of the partners that I worked with initially that there's never any boredom in this field. Either it's the Supreme Court issuing some new law or overturning law, or you have the U.S. Patent Office constantly issuing some new guidance that's going to change everything, or Congress is going to come out with some new legislation that's going to make you have to review your entire client's portfolio and decide what to do next. So it's just a very interesting field. It has implications across a wide variety of technology areas. I happen to specialize more in the life sciences because that's my background and I enjoy that. But a lot of the techniques and the strategies that apply to one field can apply to all the other fields as well. So I guess that's just a long way of saying that I had never intended on being a patent attorney, but that's what I'm doing now and I really enjoy it. And after working at the big law firm, I ended up going in-house when I moved to Rochester, and I worked for a small biotech company here. And as the only attorney at the company, I had exposure to all the other areas of law, including contract review, clinical trials, regulatory, insurance law. So I kind of started to broaden my horizon more with different areas that could have implications in the life science industry. And I find that now as a practitioner, I can add more value to my clients by having experience in the different areas of law as well.
From science to law. Some people say law is a science. Some people say it's an art. So,
and I think it's a bit of both.
Yeah, definitely. So your book, $1 Billion Patents, Strategies for Finding Opportunities, Generating Value, and Protecting Your Inventions. What led you to write this book?
Well, this is the second book that I wrote. The first book that I wrote is called Intellectual Property and Health Technologies, and it's based on the course that I created at Harvard and that I continue to teach now at Cornell. But that book was more of a textbook, and it talks about case law, and it kind of goes into the nitty-gritty of the cases. And not everyone wants to read a legal textbook, a legal treatise, so to speak. So I kind of always knew I wanted to create something more approachable to the general audience. But after writing the first book, I didn't want to write anymore for a while. But then I came across this idea of writing this book that should be an easy to read book about intellectual property. And I think my general audience for that book is entrepreneurs or people who are thinking about starting a business or people who are working in a business. And at least it introduces them to the concepts of intellectual property. It kind of talks to them about how you can build a patent portfolio, what you're looking for in a patent portfolio, and how you can kind of keep that patent portfolio not only giving value to the company, but also keeping it protected from potential challenges that may come its way.
Where can an inventor or potential patent owner can find opportunities for securing a successful patent?
Well, I think they can find opportunities in many different places. Obviously, if you create something completely new that's never been thought of before, you're more than welcome to protect that idea. If you come up with a new drug that can treat cancer or a new vaccine that can treat COVID, that's a new invention. You're entitled to protect it and you should protect it. But you can also go and find something else that already exists and try to create an improvement to it. This chair that I'm sitting on or this desk that's in front of me, if you can create an improved version of that chair or desk, you're entitled to improve it. And you can get a patent to it. So I think a lot of people tend to get scared of this concept of what can they patent? What idea can they have? And it's really, it doesn't have to be that complicated. You do have to satisfy certain requirements. It has to fulfill the subject matter requirement. It has to be novel. So it can't be something that already exists in the public domain, but it can be something that's improved upon. It also has to be non-obvious. So you can't just take something, change the color of it, and expect to get a patent on it. You do have to make some sort of an improvement to it that gives some additional value to it. And then you have to describe it in your patent application. And also it has to have a purpose to it. It has to satisfy the utility argument. So you do have certain criteria to satisfy with that patent and your invention. But it doesn't have to be as complicated as trying to create something that is going to change the world. And I think that's where a lot of people get caught up on. They think that they have to have this great idea that is going to be the next Facebook or the next, Apple, as something big and grand. But it doesn't have to be that way. You can take something that already exists and find a way to improve it. In the drug space especially, I think that's a great idea. There's so many drugs out there that have gone through phase 1 clinical trials, even phase 2 clinical trials. So they've been proven to be safe, but maybe they're not proven to be quite efficacious in the indication that they're treating. And those drugs end up getting discarded by those pharmaceutical companies because they don't want to continue with them. So taking one of those drugs and trying to figure out a modification to it, whether it's a different dosage regime, whether it's a different formulation, or better yet, a different indication. So if it went into clinical trials for treating a particular form of cancer and it didn't work, well, maybe you can take it and it can treat something else, like an inflammatory disease or something. So taking existing products and figuring out a way how to modify them and make them applicable to some other area, I think is also a wonderful way of getting a patent.
So it's not about creating a unicorn.
No, you don't have to create a unicorn. Definitely not.
It's more about finding opportunities, like research your field, understand your field, and try to find opportunities there.
Exactly. And I always recommend to my clients as well, whenever they have an idea, that they're working on to get what are called landscape studies done on that idea. So you get a sense of who's out there in your space, like who are the inventors there, who are the companies working in your space, and what are they working on? So you can kind of start seeing what other companies and people are doing in that space, what areas they're interested in. And from that alone, you can get some ideas of maybe something that you could work on. Or if something didn't work for them, you can either steer away from that, or you can choose to take your idea and use it towards that space. So you get a lot of information from those types of studies, and it gives you that kind of an idea of where you can go with your invention.
Let's say that I follow your advice. I found a great invention, which is an improvement, or I found something that it was unique, let's say, because sometimes it happens. And then I secured the patent. That's the end of the story, or what can I do? People are going to come to me because I have a patent now. Everyone is going to know. I'm going to be immediately recognized and sought after, or I have to do something else to make a profit out of my patent.
So a patent itself will not make you a profit, so to speak. A patent is just a negative right. It's something that prevents others from practicing that invention that you have patented. So it keeps people out of your space. So having said that, the patent itself, that piece of paper that you get from the patent office, is not going to do anything for you. But to make a profit, you can go a couple of different directions. One, if you want to create or develop that product by yourself, you can start a company, and then you can seek external funding, whether it's from investors or whether it's from potential partners. So you can get funding that will help you create your product that you can ultimately commercialize and then make money off of it. If you don't want to go through that whole process, because a lot of people probably don't want to start a company and go through all the hassle of trying to find money, you can just approach companies and try to license your product to them or license your patent to them. So from that perspective, you would take your patent and you would try to set up meetings with a bunch of different companies, and hopefully one of those companies would be interested in your patent, and they'll license it from you. When they license a patent from you, they usually pay a wide variety of fees to you, including like upfront fees, annual fees, different milestone payments. And then finally, the ultimate goal is getting royalties when that company ends up selling them. So from this second path forward, you don't have to commercialize anything yourself. You don't have to develop anything. You just have to find a company that's willing to do that for you. And then you get to benefit financially from that relationship.
You either want to be the one pushing forward the invention, making it happen by securing funding and by making your company, or you can find someone else who may be interested in doing that for you or acquiring that for themselves or their own companies.
Correct. So you can do either one of those, or if you are a company and you have the dreams of setting up a company, you don't have to choose between the two. You can kind of do both of them. So you can take the products that you really want to commercialize yourself, and you can go forward and try to commercialize them while seeking, some external funding to help you along the way. And then the ideas that you came up with and you patented, but you don't want to commercialize for whatever reason, you can choose to have that be a revenue stream for your company by licensing those technologies out.
You are listening to Intangiblia, the podcast of intangible law, plain talk about intellectual property.
Once I have a patent, I'm commercializing it and making a profit. What do I do to protect it? Or just by the fact that I have the patent, I don't need to worry about anything else regarding protection or regarding the markets or someone else coming forward, just because the patent is a deterrent, perhaps, from other people, and I can just relax and enjoy the fruits of my labor.
Unfortunately, I don't think you can relax too much, especially in today's climate. So I think this is a concept that a lot of people are frustrated with. They think that if you get a patent from the patent office, that should be it. That should be a valid patent. Sadly, that is not the case. And we're seeing a lot of patents being challenged either through the IPR proceedings, which are inter partes review proceedings at the patent office, which are kind of like mini litigations that are just handled by the U.S. Patent Office, or they're challenged in a district court traditional litigation setting. So we definitely have a climate right now that encourages patents to be challenged more so than in prior years. So and it completely also depends on what area you're in. I think areas in the electronic and computer spaces, those patent gets challenged more. If you're in the biotech pharma field, those patents definitely get challenged quite a bit. So if you're in one of those areas, I think you always have to monitor what's going on, what competitors are in your space. And also, when you get one patent, that may not be enough. In many cases, it's really not enough to protect yourself. And I always encourage my clients to not only protect that main concept that you're going for, but protect it in different ways. So continue innovating. That's always a good strategy, is continue developing that product, whether it's developing improvements to it, new uses for it. And then you can get multiple patents to protect your product. So if someone does challenge one of those patents, they don't only have to challenge one patent, they have to challenge multiple patents. But also just with one patent, you should never only challenge it in one way. I always like to reword my claims and have different kind of scope captured in those claims, so that, again, if that patent and a certain claim in that patent gets challenged, there are other claims also protecting your product. So you always want to have multiple layers of protection, whether it be by having multiple patents filed, but also multiple claim sets filed, so that you have those backup claims should one of them fail in either an IPR proceeding or a litigation.
And what is a claim, and what is the importance of that particular figure?
So a claim is really the substance of your patent. It defines the metes and bounds of your invention. There's two different kinds of claims out there. There are independent claims, which are standalone claims. They don't depend on anything else. And those are kind of your primary claims. You also have dependent claims that add further limitations to your independent claims. And they're usually found at the very end of your patent. There could be one claim, or there could be over 100 claims. It really depends on the patent application, the technology, but they really just set out exactly what your invention is and the scope of it. So if you're talking about a pharmaceutical drug, you're going to talk about the composition of that drug. You're going to talk about kind of the main components of it. If you're talking about something like a table, for instance, in a different space, you also want to describe it. You want to talk about having a flat surface and some legs supporting it. So you want to be able to describe your invention in some form.
So it's the heart of the invention.
Yes, it is.
Interesting.
And whenever you get into any sort of disputes over patents, it's the specific language of those claims that gets disputed. And whether or not someone is found to infringe your patent or not infringe your patent all comes down to the language of those claims.
Yeah, the words that you use are extremely important, and what they mean as well. Okay, so how do I protect my patent? I should be vigilant. I should be looking at the market, making sure everything it's going as supposed to be. So how do I protect my patent?
So, all right. So you went through the process of getting a patent. A lot of people think that's kind of it, and it's not. Like I mentioned, your patent can be challenged at any point during time. So you want to kind of remain vigilant about it. So how do you protect your patent? You want to review it from time to time. You want to review the language in it. You want to see if you think it's clear enough. Right now, we're seeing a lot happening in the written description part, and a lot of patents becoming invalidated based on not having sufficient written description support for their claims. So I think a lot of patents need to be reviewed to make sure that the application that you have on file actually supports your claims. And if you think you've got claims that are probably too broad in view of your description, you should try to file a continuation application if you can, in order to narrow the scope of those claims. Again, I think that's smart, just to have different kind of variations there and to set out different scopes for your invention. But you may also want to reissue a patent, especially if you think something was inaccurate there. So that can help you kind of get a better patent out there. I always do recommend filing continuation applications, which you can do before a patent gets issued or abandoned. But for the most part, if we're talking about something being issued, you want to file and have that continuation application on file before the patent is issued. And that gives you the opportunity to file different claims, different wording in them, especially if a new case comes through the court circuit that, in your space and tells you that it doesn't like a particular wording, having a continuation application on file always gives you that ability to modify your language.
I got my patent, I'm monitoring it, I'm protecting it, I'm making a profit, I'm commercializing it, but someone is infringing my patent. What should I do? Is litigation the only way? That's the only possible way that I can use? Or there's another way that I can come around when I found out that someone is infringing my patent?
Well, I think litigation is always probably like step 2 or step 3. Probably the initial step is to reach out to that person. You can reach out formally with like a cease and desist letter, make them put them on notice of your patent, or you can reach out even informally and kind of do the same thing. But I think the first step is trying to engage that potential infringer and try to negotiate with them. I think negotiation is always kind of probably the first step. The result of a negotiation could be that infringer ends up licensing the patent from you. You may end up giving them some rights in a limited field of use, for instance, to be able to practice your invention in exchange for, some royalties, some other kind of payments of the sort. So I think trying to approach an infringer with a negotiation, I think, is probably the best and first step forward. Sometimes that doesn't get you anywhere and you have to pursue some sort of a litigation. If you're on the side of you're the one who's infringing, I think the analysis is slightly different. Again, you may try to negotiate with the patent holder, or if you don't want to negotiate with the patent holder, you may choose to try to invalidate their patents. And then you're the one who's filing either the litigation or the IPR proceeding in order to try to do that. So I think there are kind of multiple ways, either with starting off with a negotiation, but ultimately it may end up in some dispute resolution type format.
So from infringer to business partner.
It happens. It happens all the time. And it depends on the patent that you have, what your goals are with that patent. If you want to be the only one on the market with that technology, you're probably not going to want to license it to anyone else. And you're going to try to sue the infringers on that. If, however, it's a patent that you're not really using too much yourself, or you see some value in just getting a royalty stream in an area that you're not going to be working in, why not? I think it's a potential business opportunity too.
Sounds like a good potential and also a way to turn a somewhat negative scenario into a positive one.
That's right.
If litigation is the only path, is the only viable solution that I have, because either I don't want anyone else in the market using my patent, or I just don't want that person using my patent because of other reasons. It's a big competitor, it's going to eat me out in the market, or some other reasons. How do I prepare to litigate?
Well, I think for any litigation, having the most information possible is probably the best strategy. So if you are preparing to have your own patents litigated, you need to make sure that everything, all the I's are dotted in that patent portfolio, and everything was correctly filed at the patent office. You don't want to have any sort of potential openings there for the infringer, potential or alleged infringer to exploit. So you want to go through your whole patent prosecution history, make sure you have everything lined up. You want to review your patents and, again, see if there are any weaknesses to those patents, see if you need to file a continuation, see if you need to change your scope, see if you need to file a reissue patent, for instance, but also kind of start thinking about how they might challenge your patent. Written description is something that they could challenge it on, certainly. And for that, having multiple claim scopes will help you. If they're going to challenge you on something like obviousness is always a challenging determination to make. And it usually ends up being a determination of like whose expert the court or the jury believes more. So from that perspective, you need to have your experts lined up, or at least start thinking about who can be a really good, credible expert that you can have on your team that can say that your invention was not obvious and that it was entitled to this patent. So, kind of overall, I think just having more information about your patent, its weaknesses, its strengths, and having all that lined up is probably the best way to prepare for litigation.
Do you find that in litigation, the one with the better story is the one that wins, or it's all about the technical size of the patent?
Well, I'm not a litigator, so let me preface everything I say by first saying that I do kind of assist in litigations, and I evaluate the cases, and I kind of advise on them. But I think ultimately it's probably who has the best story. And there are definitely a lot of cases where I think that patents should be upheld. I think we have the recent case with Amarin and Amarin's drug, Vasepta. I think those patents are great. I think they should have always been upheld, but every single time it went to a new court, whether it's district court or federal circuit, it got overturned, which kind of blew my mind. I think probably in those situations, it's the story that they tell, and having convincing experts on your side that makes the difference. And having a story that relates to, everyday people, or kind of tells you what's new about this technology, why it's valuable, and something that's easy to digest. If a court, often these cases are determined either by a judge panel or by the jury. And especially if something goes to the jury, most people don't want to evaluate the technical side of these technologies. It's far too complicated. So having a story that they can relate to, that they can appreciate, I think would make a bigger difference.
Because the U.S. has this unique, it's not unique, but the other countries have it, but it has this very interesting way of serving justice, which is with the jurors, a group of peers where they evaluate the situation and make a decision, which is something that, for example, from my country, we don't have it. But it's fascinating to see as well, because it's not only one technical person like a judge, it's more about everyday people that can make a decision that can affect your business. That's right. in a very important way.
Yes, and you want to have that story. You want to be a good storyteller and convince them that your technology is worthy of being there.
So how do we get to the $1 billion patent?
Well, I think kind of putting all of these things into play kind of helps you develop that portfolio. I always use Humira as a great example of the gold standard of patenting for me. And Humira is protected by over 100 patents. I think something like 136 even, which is insane. I think most products will not be protected by 136 patents. That certainly takes a lot of deep pockets in order to protect it. But I think the concept is a really good concept, and it's to protect not only your invention, but to continue innovating with it and to find different variations to your invention, or different uses for it, or different elements that could be protected. So you don't just rely on one patent for one product. You build it out so that you have this, the term patent thicket is often used. So you have this gigantic patent thicket, and that a competitor, if they wanted to enter the market, they don't just have to fight over one patent or two patents. They have to all of a sudden fight over dozens of patents. And in Humira's point, they have to fight over 100 patents, which will just take a lot of money and a lot of time. And most competitors will not do that. And so what you're left with is a product that has that market exclusivity, and it's remains kind of unchallenged by competitors on the market. So I think having or building that kind of a patent portfolio is a really good way of protecting not only your invention, protecting your marketplace, but also protecting yourself from those challenges that may come.
So it's like when you have a house, you create a fence. If you want to protect the entire house, you make the fence for the entire land, not only for the front. So any final words to the entrepreneurs, inventors that are listening?
Don't be scared of the concept of patenting. Yes, I think patents raise a lot of interesting and complicated issues, but I think the concept themselves of how to take your invention and how to protect it are not that scary. I like to say it's pretty straightforward, even though I know it's not always the case, but taking it one step at a time and protecting one concept and then another concept, and kind of staying on track of what you want to do in your market is a good way forward. And I think it's accessible to everyone across all different industries, across all different technology areas. And I do think people should not be scared of having to file a patent.
Be brave, find a patent attorney, and start your patent.
That's right. Start your journey of entrepreneurship.
Yeah, definitely. Joanna's book, $1 Billion Patents, Strategies for Finding Opportunities, Generating Value, and Protecting Your Inventions. A great book. It's written to entrepreneurs. Lawyers can also read it, but it's catered to entrepreneurs. And you can have a great understanding about patents and how to protect it and how to come about this beautiful universe of creations and innovations. Thank you so much, Joanna, for your time. Thank you for your wisdom, for sharing your ideas, your experience with us.
Thank you. And thank you for having me. It was a pleasure.
And so we come to the end of our episode. See you next Tuesday with a new guest and a new IP topic. Goodbye from Washington, D.C.
Thank you for listening to Intangiblia, the podcast of intangible law. Plain talk about intellectual property. Did you like what we talked today? Please share with your network. Do you want to learn more about intellectual property? Subscribe now on your favorite podcast player. Follow us on Instagram, Facebook, LinkedIn, and Twitter. Visit our website www.intangiblia.com. Copyright Leticia Caminero 2020. All rights reserved. This podcast is provided for information purposes only.